Hey folks, welcome back to the Law and Crime Network. I'm Michel Bryant with you for the afternoon session. John Phillips with me on the set, and Bremner is going to join us as well. I'm sorry, I'm kind of schwitzing here. Hot day in New York, so I'm sorry, John. And, you know, suits and hot humidity, bad combination, but it's not smell-o-vision, so we're good. We came up with a verdict today, not just in the Vasada penalty phase, but they finally came up with their decision, which we're going to get into in some detail a little bit later. You remember he was found guilty of the murder of 3 people in the backyard during that Super Bowl party. Well, the jury came back with the good old LWOP, life without possibility of parole. So we're going to get into the details of that case coming up. But more importantly, at this moment, we're in jury verdict watch in the Scott Nelson case out of Florida. As you recall, this is the brutal case and unbelievable case regarding Jennifer Fulford's death, the nanny who was killed by the defendant. I'm not just saying it. He admitted it. And the charges pending are first-degree murder, burglary, kidnapping, carjacking, witness tampering. The potential penalty is death. The jury has just asked for some interesting things when you consider the nature of this case and the nature of this man's testimony, which basically said, yeah, I did it. Yeah, I did it. But I think they might be focusing on whether he intended to do it, because that was some of his testimony yesterday. They've asked for some of his testimony, in fact, all of it. They wanted a transcript of the entire testimony, and the judge said, no. Rely on your collective recollections, and sent them back to work. They also asked for some letters. We've had them here on the set that were not introduced into evidence, so that's not going back to the jury room either. But what it tells us is they got a lot of thinking going on in that room. We were taking bets on how many minutes it might take for a verdict, and that looks like they're doing some work. And generally, I think that might bode well for the defense. So let's take a look at how the closings rolled out. Okay, let's start with the prosecution, some of the closing arguments in the Scott Nelson case. So there's Linda Drain-Burdick. She's the prosecutor laying out a chunk of the case there in part of her closing argument. The name may sound familiar. She tried the Casey Anthony case. Now, John Phillips, trial attorney, is with me here. When thinking about those two cases, you got to think this one is the theoretical slam dunk, right? I mean, you would. Wouldn't you think that? And yet we're already hearing the jury wrestling with it. What are your thoughts?
Well, any time you're dealing with life and death, essentially, for this man, they're gonna go through it, and they're gonna take it with a level of seriousness. It is time, though. You know, it's any time now. I would expect a verdict.
Okay, and it seems to me, just my gut feeling, that this kind of thoroughness is a good thing for the defendant, yes or no?
Yes. And I was at the Casey Anthony trial, and that was a pretty quick verdict.
And what do you think? What do you compare the two? I mean, the job that Burdick has had to do in the two relative cases.
Well, you know, I think that case was stunning to everybody that it was an acquittal that quickly, and based on a lack of evidence about not the manner of death, the cause of death, you know, per the jurors. This one is basically, you know, looking at like, this is such a bizarre defense that maybe we should kind of look at it for a while. But the fact they're looking at it, like you said, it bodes well for the defense, because a lot of us would look at it and go, oh my, this is just not believable.
You're right. And so I credit to the defense for the work they've done, and credit to the jury for what they're doing right now. Let's go back into the courtroom now for more of the prosecution closing argument. So I know I feel sorry for Mr. Nelson. He's gone through quite a bit. So this was about him getting on the stand, telling everybody his story, blaming everybody he wanted to blame, taking zero responsibility. And Bremner, trial attorney, I'm seeing total loss of control by this defense team of their client. What do you think?
Absolutely. And as your viewers know, that it's his right to testify. The lawyers don't make that call. It's his decision and his decision alone. He made it, I'm sure, against their advice. He playing himself like a victim like this is just, at least from what I'm seeing so far, it's just reprehensible. And I can't imagine any of the jurors buying it. You know, like, my probation officer really killed her, is what he's saying.
Yeah, I mean, it's outrageous the way he's going about it. And I do credit the defense for at least planting some nugget in this jury's mind. John Phillips, is it going to work ultimately?
I have to think that he had something in his head that he thought he was sacrificing himself for this criminal justice attack. Let everybody know what's really going on in the criminal justice system. Certainly nobody thinks he's going to get off. The question is, you know, did his appeal affect one person? I don't get it. That his testimony yesterday was one of the most shocking things I've seen.
And he may get just what he wants. He may get to be a martyr if they find him guilty and then put him to death, or at least recommend death. We're going to get back into that courtroom. You heard the prosecutor mention some of the outrageous things said by the defendant. If you haven't heard it yet, I watched it again before bed last night. Not a good idea, believe me. But we're going to listen to some of those outrageous comments when we come right back to the Law&Crime Network. Well, there he is, Mr. Wonderful. I mean, he's despicable. He has disdain for the system, for everybody around it, because it's all fallen down on him. John Phillips, trial attorney, is here. You had one good word to describe the guy.
I did. I said he's so hateable, and we're supposed to be unbiased and stand for justice. But he's just so smarmy, and I feel so bad for the victim's family here, having to watch this and see him be so cavalier about taking her life.
Some of the things he said, while the husband's in the audience as well as the other family members, when asked about something she did or didn't do when he was taking her out of the car, I don't know, why don't you ask her? I mean, outrageous. And, it makes me glad that he didn't take the plea deal they offered just before trial, because I'm sure that would have taken the death penalty off the table. But it sounds to me like you don't take a plea. Why?
I mean, this is just outrageous. I keep thinking a jury would want to kill him once and kill him again. I mean, he's just horrible.
Yeah, and so, I mean, I think the defense had to do their job, and we're going to see some of that in just a moment here. But what do they got to work with when you have this guy on the stand?
He's so hateable, as was just indicated. He's so reprehensible. But can you really go there and say, he's part of this whole Me Too or Me generation? It's all about me. He's a product of the system. Do they want to run with that? Or do they just want to say that this is someone that may deserve mercy? There were extenuating circumstances. He said had a terrible life. And even though you may hate him or not like him, you have to see from whence he came to understand, what he did.
And I suppose, they'll have two whacks at that sort of sympathy, one in the guilt phase and probably one in the penalty phase. So let's take a look now at some of the defense work in this case. Let me save that for you. We're going to take a quick break, then we're going to come back to the defense closing. John, what happens next? What's the dynamic takes place? Jury's not present. Right. Counsel are looking at the note. What happens there?
There's a huddle, as you said, to determine how to respond. And both sides generally have to agree for there to be a joint response. Otherwise, the judge will do what he's got to do. The jury instructions in Florida could be reread. Oftentimes they go back there with them. It's like, look at page 2.
Read it again.
Yeah, but it's an interesting question.
So what we would expect here, and this is what we saw the judge do earlier today on these prior questions, he crafted his response, and then he asked for each side on the record to agree with his planned presentation. Again, trying to cover himself for appeal, right, Ann Bremner? Is that an issue that he's trying to avoid?
Absolutely. And, the fact is that he's very careful of making sure that the record's clear. And he's saying, I'm doing this for this reason. And he's doing it with the lawyers. And he'll bring the jurors out. He'll make a record of what he says to them. So everything is crystal clear and it's perfection that can't really be set aside in an appeal. Okay.
And that's jury instructions are one of the huge issues on appeal. We're going to get back to that courtroom as soon as they start doing more than just reading notes back and forth. We'll let you know what's going on there. But in the meantime, let's listen to more of the defense closing argument in the Nelson case. So again, more of the defense closing argument there, focusing on intent. What was the defendant's intent? And when we talk about this, John Phillips, trial attorney from Florida, we're balancing what the confession said and what the defendant said on the stand. Quite often you don't have that luxury of comparing those things. And he's basically saying, the defendant's saying, oh, a lot of what I told the cops was just garbage. Right. Just trying to play with them. What I'm saying right now on the stand is the truth, and I never intended to kill this woman.
I was raised in Alabama. My mama used to say, a liar's a liar and a thief's a thief. And so jurors tend to believe that. And so it's somebody in that jury room is going to say, well, do I believe him then or I do believe him now? And you got to toss out all of it. He did it. He admitted he did it. Now the question is this first degree? Is this felony murder? What do we have left? Yeah.
And so, Ann, as the jury is clearly tearing this apart and focusing on intent, within that category, what do you see being the key pieces of evidence that they need to look at?
Well, I mean, they basically just need to look at what he did in the crime and then what he said after the fact in terms of what he meant to do. I mean, his key to the testimony was, I didn't mean to kill her. I didn't mean to kill her. So they're looking at all the other evidence,
15684.
to see whether or not he did. But then you look at the underlying intent in the felony murder underlying felonies like, burglary, arson, rape, kidnapping, etc. And then you just take that. You're in for a dime. You're in for a dollar. You did felony. There's death. Guilty.
Right. Yeah, and I know the defense tried to say, well, it wasn't kidnapping, it was false imprisonment. And it wasn't robbery, it was burglary. And I get that, the distinction he's trying to make is, property crimes versus level of personal crime, crime against a person, because that needs to be the predicate for the murder that they're trying to connect to. But it seems to avoid the bigger issue. And I think what the defendant has been saying is, look, it just happened. She was spouting off. I wanted to keep her quiet. I duct taped her, and then that didn't work, so I stabbed her. And it was all heat of passion type, heat of the moment stuff, which mitigates the murder. I just don't know if the jury's going to buy that. We're going to find out, though. We are in verdict watch in that case out of Florida. The Scott Nelson jury busy at work. And we will be right back to the Law&Crime Network.